Start with the basics. The Indian Partnership Act 1932 lays the foundation for how partnerships operate in India. A partnership is essentially a relationship between people who agree to share the profits of a business carried on by all or any of them acting for all. These individuals are called partners, and together they form a firm operating under a firm name. Importantly, this relationship is based on a contract, not on status or family ties. For example, members of a Hindu undivided family running a family business are not considered partners under this act. The act also clarifies that simply sharing profits or owning property together doesn't automatically make you partners. The real relationship and intentions matter, and all relevant facts are considered to determine if a partnership exists. Now let's talk about how partners interact and what their rights and responsibilities are. The act says that unless otherwise agreed, all partners have the right to take part in running the business and must act in the firm's best interest. They should be honest, keep true accounts, and share all relevant information. Profits and losses are usually shared equally, and partners are not entitled to a salary for their work unless the partnership contract says so. If a partner causes loss by fraud or willful neglect, they must compensate the firm. Partners can also inspect the firm's books, and in case of a partner's death, their heirs have similar rights. The act allows partners to set their own rules through a contract, which can be changed only with everyone's consent. Key aspect of partnerships is how partners can bind the firm and each other. Every partner is considered an agent of the firm, meaning their actions in the usual course of business bind the firm. This is called implied authority. However, there are limits. Partners can't, for example, sell firm property or admit liability in court unless specifically authorized. If a partner acts beyond their authority, the firm is only bound if the other party didn't know about the limits. Importantly, all partners are jointly and severally liable for the firm's actions while they are partners. This means creditors can go after any or all partners for the firm's debts. The act also covers what happens when a partner retires, is expelled, or becomes insolvent, and how liabilities are handled in those cases. Finally, let's look at how partnerships end and the importance of registration. A partnership can be dissolved by agreement on the happening of certain events or by court order. After dissolution, the firm's assets are used to pay debts and any surplus is distributed among partners. Registration of a firm is not mandatory, but it's crucial for enforcing rights in court. Unregistered firms face restrictions. They can't sue to enforce contract rights. Registration involves submitting details to the registrar of firms, and any changes in the firm's constitution, name, or address must be notified. The Act also prescribes penalties for not complying with these requirements and lays out the process for inspection and amendment of records. This ensures transparency and legal certainty for all parties involved.